Alien Enemies Act, and more. Welcome to Law and Society. Please subscribe. What I'm going to do today is briefly go over the latest news that I saw and a couple of things before I go into the ruling by Judge Rodriguez in a case in the Southern District of Texas, Brownsville Division. So, in terms of and more, we now know today that Donald Trump's national security advisor, Mike Waltz, and his deputy they're no longer there. They've been let go. There's some talk about him putting Mike Waltz as the ambassador to the United Nations. That requires Senate confirmation, and of course, with the cowering Senate that keeps giving away its advice and consent power, we will probably have him become the United Nations ambassador. But we know that this has to be the fallout from the Signal chat. And honestly, if Donald Trump is letting Mike Waltz go, he needs to also let Pete Hegseth go. And I wouldn't be surprised if Pete Hegseth is also on his way out in the next couple of months. Another person who really needs to go is Robert F. Kennedy Jr. In the latest of his antics, the U.S. Department of Health and Human Services the secretary has asked the CDC for a nationwide scientific process on treating measles and other conditions with medications, as well as alternative therapies such as vitamins, HHS said in a statement. Listen, there are some things for which you have to take medicine and get vaccinated, and there are some things that you take vitamins and supplements for. There's a reason why there is a prescription, some are prescribed and the vitamins and such are not. It's because medical professionals who have dedicated over a decade at least of their life on learning how the human body works and what drugs to use, they have, through rigorous process, come up with vaccines and drugs to deal with serious diseases like measles, tuberculosis, and other infectious diseases like HIV. And Bobby Kennedy's Health and Human Services is pulling funding from state grants that go towards preventative programs for infectious diseases like measles, rubella, mumps, HIV, tuberculosis, and we already have gone over, we're at over, I think, 900 people who have been diagnosed with measles so far, or close to 900. So I had to bring that up and talk about it briefly because Bobby needs to go as well. He needs to take his therapies and get out. Then there was this talk in Donald Trump said that, maybe this Christmas, instead of 30 dolls, you'll get 2. It's another way of saying things are going to be more expensive and I'm not keeping my promises of bringing down the cost of living and, raising the standard of living and making everything good and great. But it also gives us another window into how out of touch Donald is about what most Americans do or get during Christmas. And there are families where you get a lot of presents. But there are many, many, many families in the United States who don't have money to get 2 dolls. They are working on their way to get that 1 doll that their child wanted all year round. So to be able to joke about it in such a sort of blasé way. It's like, well, whatever. You get $2. Don't have to get 30. Who gets $30? Did Donald Trump get $30 when he was a kid? I'm sure he did. That's why he believes what he believes, or maybe he didn't, and that's why he's so angry about it, or whatever the head case may be about that. CNN also reports that Donald Trump signed an executive order directing the Corporation for Public Broadcasting to end federal funding for America's two biggest public broadcasters, which have faced a series of attacks from the White House and Republican lawmakers accusing them of biased reporting. And that's talking about NPR and PBS. They are about as balanced as news gets. This is nothing if not an open fight against the First Amendment right to a free press. If you are also the executive does not have the power to appropriate money or regulate spending. That is Congress's domain. And if Congress has specifically allocated this money for funding programs and funding PBS and NPR, then that funding cannot be stopped by Donald Trump unilaterally. It has to come from Congress through legislation. Much like a lot of other things that Donald Trump is doing. And, as I've been going through the days, some existential things, you never stop detesting Mitch McConnell. I mean, he screwed us over in so many ways. He's not related to anything, but I just wanted to talk about him and remind y'all that if it wasn't for Mitch McConnell, we wouldn't have had, we would have had Merrick Garland as Supreme Court Justice, and we wouldn't have had Merrick Garland as the Attorney General. We also wouldn't have had, likely, the ruling of presidential immunity. And if it wasn't for Mitch McConnell, he probably could have gotten us the 67 votes that we needed. Remember that Donald Trump's impeachment in the second time, because of January 6th, the Senate was only 10 votes short. 57 senators voted to convict him. So Mitch McConnell could have brought 9 more along with him as majority leader, but he relented and therefore did not disqualify Donald Trump, relenting to the courts. And then Merrick Garland does what he does, as we've seen in the last 4 years. And here we are with Donald Trump's regime. You have to put some of that responsibility where it lies. This person who's now quietly voting against Donald Trump and making news about it has been instrumental in Donald Trump escaping liability. Never forget it. The next thing, before I go into that case about the Alien Enemies Act, I love watching Heather Cox Richardson. Professor Richardson goes out on these talks, and she recently had a talk at a women's club, Montgomery Women's Club, I believe. And somebody asked her a question about, what is your therapy? For many of us, letters from an American is the therapy and the news that we need. And it so very much is. It's therapeutic to read her words. And in a way, I felt empowered by it, because she's this huge scholar who is lending her voice to the public of what we should be doing. And she talked about people and engaged citizens going out and making short videos, going out and writing, and everybody working towards that and engaging. And that was so heartening to see how dedicated she is to that therapeutic project for her, which is informing the American public. It's a noble endeavor where she doesn't make any money from it, and she just informs the American people. And also her copy editor, who said that, when she was asked if there's going to be some rest because she just had surgery, I think the day before this talk happened, she said that as soon as she got off anesthesia, she would be back to her task. So that gives you an idea of there are these people who love our country so very much, and we are doing whatever we can to, if nothing else, bring information to you, to others, so you may be able to be informed about what is going on in the country. So at the 10-minute mark, I'm going to switch to the case. If you don't want to hear about the Alien Enemies Act case and therefore the people who are being illegally removed from the United States, then this would be the time for you to leave. And I thank you very much for your time. I, however, urge that you do remain and listen to the excerpts from this ruling. And before I go into the ruling, right before I was getting ready to talk to you about this ruling and today's episode, the Trump administration filed in the District of Columbia a brief that has to do with the Alien Enemies Act and how Donald Trump's authority is plenary. I haven't read that court filing yet, and I don't know which case exactly that is part of. I can quickly find out though. But I am going to, let's see what the case is about. That is in the GG et al. Case that is in the District of Columbia. Okay, so it's one of the motions that has been filed in the case in which I believe is now in Judge Sinis's court on remand. No, that is the Abrego Garcia case. There are so many cases, but this is one of their things, and I'll read through it, and if it's important, I'll report back. But for now, this Alien Enemies Act order is the law of the Southern District of Texas, and in the absence of any other precedent, this is the first substantive ruling that says why legally both that the court has jurisdiction, the judicial review aspect of it remains, and also why the Alien Enemies Act does not apply. The jurisdictional battle is important to understand because Donald Trump raises this over and over again, that because Donald Trump is using his foreign powers, his core executive duties, based on, mind you, that immunity ruling by the Supreme Court, that he has plenary authority once he declares these powers and he proclaims them. But it is the purview of the courts to say what the law is and apply it to the facts. So whether or not the law applies, whether or not the invocation itself applies to the facts in the case, is the purview of the courts. It's in between Donald Trump's proclamation and its effect, constitutionality, dependent on the statute through which the president's powers have been invoked, being the Alien Enemies Act, which is through which he's pushing people out of the country. So now I'm going to go into the ruling, and I'll read out excerpts that I've thought to be, would tie the story together. quick drink of water. Just so you know, I am eternally thankful to all of you for coming and listening to me, and how many ever there are, because I think it's important for you and me to engage. And please leave comments. Please, if you have questions, let me know what they are. I'll do my best to provide you the answers. So, order and opinion of the court. Under the authority of the AEA, which is the Alien Enemies Act, the president proclaimed that all Venezuelan citizens 14 years of age or older who are members of the TDA, which is the Tren de Aragua gang, these are abbreviations which will come up several times, are within the United States and not actually naturalized or lawful permanent residents of the United States, are liable to be apprehended, restrained, secured, and removed as alien enemies. The petitioners in this case are natives of Venezuela currently detained at a Texas facility detention center, and they are bringing this lawsuit alleging that by seeking to remove them from the United States based on the proclamation made by Donald Trump, the government, respondents do so unlawfully in violation of their due process rights under the Fifth Amendment of the Constitution. Petitioners challenge that the president can invoke the AEA under alleged circumstances and also deny that they are members of the Tren de Aragua gang. Petitioners seek a permanent injunction barring respondents from employing the AEA to remove them. The question that the lawsuit presents is whether the president can utilize a specific statute, the AEA, to detain and remove Venezuelan aliens who are members of TDA. As to that question, the historical record renders clear that the president's invocation of the AEA through the proclamation exceeds the scope of the statute and is contrary to the plain, ordinary meaning of the statute's terms. The court, as a result, concludes that, as a matter of law, the executive branch cannot rely on the AEA based on the proclamation to detain named petitioners and the certified class or to remove them from the country. So it's not just about the named plaintiffs, but also the certified class, and we'll hear that later on, where there's a talk about, although the case about these plaintiffs is now moot, that the case continues to remain very much, ripe and ready to be presented to the court as to all the class members who are part of this class. And the court also says that, in a footnote, although this conclusion renders it unnecessary to reach all the challenges that petitioners present, to facilitate appellate review, the fact-finding court has the power to do, the plenary power to do, the evidentiary fact-finding. The court reaches some of those issues. So it's letting us know that we are going to get a comprehensive lesson on what the court thinks is the applicability and where even the government got it right, where the court is not granting fully what the petitioners ask, but the ruling stands that the petitioners cannot be held and detained under this act. The AEA stands at the center of this lawsuit and reads, whenever there is a declared war between the United States and any foreign nation or government, or any invasion of predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the president makes public proclamation of the event, all native citizens, denizens, and or subjects of the hostile nation or government being of the age of 14 years and upward, who shall be within the United States and not actually naturalized, remember that, not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. The president is authorized in any such event by his proclamation thereof or other public act to direct the conduct to be observed on the part of the United States toward the aliens who become so liable. So the part that's important here is whenever there is a declared war between the United States and any foreign nation or government, that's relevant, but that's not why the AEA doesn't apply. Or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by a foreign nation. We're going to see how the court unwinds and says that no, it doesn't rise to the level of any invasion or predatory incursion. The AEA grants broad powers to the president, who may invoke the statute when declared war exists between the United States and a foreign nation or government, or when any invasion or predatory incursion is perpetuated, attempted, or threatened against the territory of the United States by any foreign nation or government. The president must make a public proclamation of the event. The statute authorizes the president by his proclamation to direct the conduct of the aliens. The president can determine the manner and degree of the restraint to which the alien shall be subject. So laying out the parts where that would apply. Here providing examples of when they have applied. They've only been during wartime. And the court says in July 1945, after the Axis powers in Europe had unconditionally surrendered, President Harry Truman issued an amended proclamation that permitted the removal of Japanese, German, Italian, Bulgarian, Hungarian, and Romanian aliens whom the Attorney General deemed to be dangerous to the public peace and safety of the United States because they had adhered to the aforesaid enemy governments or to the principles of government thereof. In 2011, Obama issued an executive order, now talking about Tren de Aragua, to block property ownership by transnational criminal organizations. And they define these transnational organizations, and the court defines it for the record. The company annex index specific trans criminal organizations, but not the Tren de Aragua. In July 2024, the Treasury Department placed the Tren de Aragua in its sanctions list as a significant transnational criminal organization, TCO. On March 15th, 2015, Donald Trump issued the proclamation at issue in this lawsuit. The proclamation included several statements regarding TDA and the Venezuelan governments, saying that TDA operates in conjunction with Cartel de los Soles and Nicolas Maduro regime is sponsoring this, and they're engaged in mass illegal immigration. And like Eli Assimi, who I assume is another part of the government or this apparatus, who claims to be Venezuela's, Nicolas Maduro, who claims to be Venezuela's president, asserts control over the security forces of Venezuela, blah, 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 blah. The Venezuelan nationals who, are being sent. So this idea, the president proclaimed that I find and declare that Tren de Aragua is perpetuating, attempting, and threatening an invasion or predatory incursion against the United States. So the petitioners say that they came from Venezuela seeking asylum. One petitioner, persecution from Venezuela. He was arrested at his asylum interview. The other petitioner is a Venezuelan national who alleges that he entered the United States to escape torture in Venezuela because a family member is a known political dissident. The other petitioner is a Venezuelan national who lived in Brooklyn with his wife and stepdaughter. And he was arrested on March 7th as a gang associate. Petitioners' claims for relief necessarily imply the invalidity of their confinement and removal under AEA. Their claims fall within the core writ of habeas corpus that must be brought in habeas. That is in Trump v. JGG, which is a ruling that the Supreme Court is required just released. That habeas relief, their claims fall within the habeas relief and they must be afforded habeas corpus relief. The ruling required petitioners to file a habeas action in the district of their detention. So this is the procedural history. On April 9th, petitioners filed their class petition for writ of habeas corpus. They challenged respondents' ability to remove them based on the proclamation and AEA, and also deny their membership in Tren de Aragua. They sought to represent a class of all non-citizens in custody in the Southern District of Texas who are, or will be subject to the proclamation or its implementation. And this class was, this is a certified class. On April 9th, the court granted the motion and enjoined the respondents from transferring, relocating, or removing these petitioners or any other persons under the class, under the proclamation from the detention center. Moving on May 1st, the court granted petitioners' motion to certify and certified a class composed of Venezuelan aliens 14 years or older who have not been naturalized, who respondents have designated or in the future designate as alien enemies under the proclamation being the executive order that Donald Trump has issued about Tren de Aragua and the removing of these people without due process. Respondents are designated or in future designated as alien enemies under the proclamation and who are detained or reside in the Southern District of Texas. Now, that is important because this case is in the Southern District of Texas, and so it applies to even the people who Donald Trump's bringing into the detention facility in Texas over which this court has jurisdiction. So there's a good chance, and keep an eye out, that Donald Trump may find another jurisdiction in Texas where he starts to detain them and go through the same rigmarole argument, but at least that court will have this court's order. The habeas relief by challenging, petitioners seek habeas relief by challenging the invocation of the Alien Enemies Act on 3 grounds. First, proclamation fails to provide petitioners with reasonable notice and a meaningful opportunity to challenge their designation as alien enemies. 2, the proclamation doesn't fall within the statutory bounds of the AEA, both because no invasion or predatory incursion has occurred or been threatened, and no foreign nations or government have engaged in such conduct. And 3rd, petitioners claim that the proclamation violates the specific protections that Congress established in the Immigration and Naturalization Act for non-citizens seeking humanitarian protection. Respondents contest the validity on each ground, arguing that no jurisdiction exists to review the president's proclamation, which is something that they have reiterated in the filing that they just made a few hours ago, by the way. So they are going to keep going from jurisdiction to jurisdiction with these same arguments and see what the courts have to say. And I'm sure they're going to move jurisdiction because now this jurisdiction is not in their favor. So in order to skirt this order, they may start detaining people who are who are being held under the Alien Enemies Act in another detention facility in another place where that district doesn't have immediate oversight over. But the court there hasn't been any adjudication on this matter. So the only persuasive precedent that jurisdiction would have would be this opinion. And that's why this opinion is important. I'm already at the 31-minute mark. So this will go a little long, and hopefully it'll capture the essence of the ruling. Let's see here. Then there's questions about the political questions doctrine, and the court doesn't really, the court says that, the political question doctrine, we're not even going to have to deal with that because we're not talking about whether the proclamation is constitutional or not. We're talking about whether the words of invasion and predatory incursion, apply to these people who are not part of the gangs. So the court provides some historic precedent. In the context of World War II, the Supreme Court considered challenges concerning the Enemies Alien Act. In at least 2 of those cases, the nation's high court recognized the broad powers of the act placed in the president. The very nature of the president's power to order the removal of all enemy aliens rejects the notion that courts may pass judgment upon the exercise of his discretion. Executive power over enemy aliens, undelayed and unhampered by litigation, has been deemed throughout our history essential to wartime security. It's wartime security. In those decisions, however, the Supreme Court also identified issues related to the AEA that are subject to adjudication. In Ludek, the Supreme Court confirmed that resorts to the court may be had to challenge the construction and validity of the statute and to question the existence of the declared war. So the factual assertion of whether there is a war or not is something that the court can determine. Relying on these decisions, the Supreme Court recently affirmed that an individual subject to detention and removal under AEA is entitled to judicial review as to questions of interpretation and constitutionality of the act, as well as whether he or she is in fact an alien enemy 14 years of age or older. Then there's a precedent of Baker v. Carr that talks about where the political doctrine applies and all of that. The court says the Supreme Court in JGG confirmed that questions and interpretations fall within the judiciary's responsibility. One of the judiciary's characteristic roles is to interpret statutes, and we cannot shirk this responsibility merely because our decision may have significant political overtones. This is coming from another U.S. precedent. The overtones doesn't matter. The political question thing is a separate thing from having political overtones. The Second Circuit during the 1940s construed various provisions of the AEA, and the court is unaware of any judicial authority declining to determine the meaning of AEA's terms based on the political questions doctrine. So there's a lot of talk about the political questions doctrine and how much of it applies. Then there's the notice procedures, where, the notice procedures are moot now as it applies to the named petitioners, but not the class members, and not the class members who will be held under this proclamation. Petitioners contend that AEA fails to provide adequate due process to the individuals designated as alien enemies. President must provide notice to individuals designated as alien enemies, and notice must be afforded within a reasonable time and in a manner that will allow AEA detainees to actually seek habeas relief in the proper venue before removal occurs. Respondent's position is AEA and due process rights are satisfied by giving individuals designated 12 hours to express intent to file habeas action and an additional 24 hours to initiate that claim. So like ramping up the process and not really providing them with due process as would happen in the course of law. You give them this much time, 24 hours. You have to find a lawyer, get them to file a writ of habeas corpus, get up to date with the law and everything that has to do with this case. So the burden being put on the people is just quite high. In the present case, the notice that the AEA requires serves to allow the designated individuals the ability to actually seek habeas relief in the proper venue. And the same, okay. Individuals who currently in future detained or reside in the Southern District of Texas who respondents designate as alien enemies under the proclamation. That's claiming the jurisdiction. I'm skipping through large portions of it, especially since I've already crossed 38 minutes. Invocation of the Alien Enemies Act. Petitioners dispute that any invasion or predatory incursion has occurred, been threatened, or been attempted, as well as that any foreign nation or government has engaged in any conduct. When ascertaining the plain, ordinary meaning of the statutory language that harkens back to the nation's founding era, courts rely on contemporaneous dictionary definitions and historical records that reveal the common usage of the term at issue. In addition, in determining the meaning of a particular statutory provision, it is helpful to consider the interpretation of other statutory provisions that employ the small or similar language. Moving. Invasion and predatory incursion. Petitioners argue that the proper construction of invasion and predatory incursion reveals that the proclamation doesn't satisfy the conditions required to invoke the statutes. They highlight that Congress enacted the AEA as a wartime measure, and that Congress understood invasion and predatory incursion to mean military incursion into the territory of the United States. They also note accurately that no president has invoked AEA other than during a time of war, including the War of 1812, World War I, and World War II. Respondents urge a broader meaning. They contend that while the definition for those include military action, they are neither limited to such action. According to respondents, an invasion can include any hostile entrance. Petitioner's brief contains numerous sources, so the people who are asking for relief, numerous sources contemporaneous to the enactment of the AEA, in which invasion and predatory incursion expressly references or imply military action. Those sources include dictionary definitions, historical records, letters, and court decisions. Respondent doesn't challenge to these usages. In support of their construction, however, they provide only two examples, both from dictionaries, and no other historical records support the meaning of invasion, that offer no sources from the nation's founding era as to the ordinary meaning of predatory incursion. The court reviewed numerous historical records using invasion, predatory incursion, and incursion in the period from 1780 to 1820. The review strongly supported the petitioner's position. In the significant majority of records, the use of invasion and predatory incursion referred to an attack by military forces. The usage of predatory incursion at times referred to entries of Native Americans into Western territories, as did usages of incursion. The court's research and judicial decisions that utilized predatory incursion during the relevant time period returned only two results. In both usages, the courts referred predatory incursion to describe conduct by Native Americans, in one instance as part of an Indian war, and in the other in connection with the authority of a military officer. Now talking about historical debate, Representative Robert Harper moved to strike the phrase predatory incursion from the proposed legislation based on his belief that the bill granted very extensive powers that he did not think ought to be given in case of serious attack. Except in case of serious attack, The usage of this record suggests that members viewed predatory incursion as a term implicitly referencing a serious attack. The Constitution references invasion in two occasions, each time in a military context. In Article 4, Section 4, where it says at least one court has concluded that invasion requires protect each state against invasion. At least one court has concluded that invasion under this provision requires armed hostiles and does not include mass immigration. This was in 1996, and it was the Third Circuit. The historical records that parties present, supplemented by additional records that court reviewed, demonstrate that at the time of AEA's enactment, the plain, ordinary meaning of invasion was an entry into the nation's territory by a military force or an organized armed force with the purpose of conquering or obtaining control over territory. In the same vein, the common usage of predatory incursion was to a lesser degree. Incursion referenced a military force or an organized armed force entered the territory to destroy property, plunder, and harm individuals with a subsequent retreat from that territory. Although other uses exist for those terms, those rare uses do not present the ordinary meaning of those terms. The court, however, does not adopt the petitioner's position. Instead, Congress identified 3 scenarios that enable a president to invoke the AEA. That's declared war, invasion, or predatory incursion. The structure of the AEA does not require the latter 2 must be precursors to the first. So, moving forward. While the court finds that an invasion or predatory incursion must involve organized armed and force entering the United States to engage in conduct destructive of property and human life in a specific geographical area, the action need not be a precursor to actual war. So, giving you the limits, now the application. First, the court finds that the proclamation places the government of Venezuela as the controlling entity. It doesn't refute that. The proclamation declares the country of Venezuela through Maduro directs Trinidad activities in the United States. The court does not, question that. As for activities of these Venezuelan TDA, and as described in the proclamation, the court concludes that they do not fall within the plain ordinary meaning of invasion or predatory incursion for purposes of the AEA. That's the important part. Those factual statements depict conduct by TDA that unambiguously is harmful to society in this country. The political question doctrine prohibits the court from weighing the truth of the factual statements. Instead, the court determines whether the factual statements in the proclamation, taken as true, describe as invasion or predatory incursions for the purposes of the AEA. Based on the plain and ordinary meaning of those terms, the court concludes that the factual statements do not. The proclamation makes no reference to or in any manner suggests that a threat exists of an organized armed group of individuals entering the United States at the direction of Venezuela to conquer the country or assume control over a portion of the nation. Thus, the proclamation's language cannot be read as describing conduct that falls within the meaning of invasion or for the purposes of the AEA. As for predatory incursion, while the proclamation references TDA members have harmed the lives of in the United States and engaged in crime, the proclamation does not suggest that they have done so through organized armed attack, or that Venezuela has threatened or attempted to attack through TDA members. As a result, the proclamation also falls short of describing predatory incursion as that concept was understood at the time of AEA's enactment. The court concludes that the president's invocation of AEA through the proclamation exceeds the scope of the statute and, as a result, is unlawful. So, that is the case for you. The court concluded that the petitioners, in their individual capacity and representatives of the certified class, had demonstrated entitlement to relief in habeas. Respondents have designated or will designate them as alien enemies under the proclamation, subjecting them to unlawful detention, transfer, and removal under the AEA. As a result, petitioners are each entitled to granting their petition of writ of habeas corpus and a permanent injunction prohibiting respondents from employing the proclamation and the AEA against them. The certified class warrants similar protection. The court will issue a final judgment to the appropriate relief. So, to the extent that petitioners or any member of the certified class have been detained or are detained in the future pursuant to the Immigration Nationality Act, they have not sought and do not obtain relief. So the people who are petitioners are, this is just a habeas corpus petition, and that is granted. And the Alien Enemies Act does not apply because the government was not able to establish that there was an invasion or predatory incursion, and that war doesn't have to be there. But it couldn't prove to this fact-finding court that there was an invasion or predatory incursion, or that the people who have brought suit and who are being detained under this proclamation have not acted in any way in sort of an organized manner that would fall within the way of how you would think a predatory incursion or an invasion would happen. Also, the fact that the context of when the AEA was applied was during a time of war. The court doesn't make any ruling specific that it only applies to a time of war, and says it doesn't have to. But in this case, even if it doesn't have to, the other two requirements of there being an invasion or predatory incursion are not satisfied by the government. So this is one way of going about the Alien Enemies Act. And we're going to see other judges come up with other reasonings. And I'm looking forward to what Judge Sinis has to say in regard to the Abrego Garcia case in her court that is now in sort of swinging in discovery where the government is stonewalling. So with that said, I've now come to 51 minutes. If you are listening, thank you so much for being here. If you've arrived somewhere in the middle, it might seem to be a little, in the deep end, thrown into the deep end, but I was reading the order by Judge Fernando Rodriguez of the Southern District of Texas, Brownsville Division, who granted the writ of habeas corpus and the permanent injunction of to remove these people from the United States. And so I'm sure it's going to be appealed. It's going to go up to the Supreme Court. Then we'll have to see what the Supreme Court has to say. I hope that they realize now that they have to give a direct order to SCOTUS in order to nullify that executive order. They have to give a direct order to bring back the people who have been illegally removed. They have to give a direct order that affirms this court's ruling that it is wrong application of the Alien Enemies Act. There can be no minced words. There can be no interpretation. There can be no remanding. None of that. And I hope the Supreme Court realizes that by the weight of their decision to stop further deportations in one of the cases when they ruled at 1 a.m. in a 7-2 ruling to stop that movement of those people. And the buses were turned around immediately. They were going to the buses. That's how imminent that was. So with that said, thank you for giving me so much of your time. Please go and read the opinion yourself. Please go and talk to others about what this opinion means. It is a beacon of light in a period of darkness. So, with that said, thank you and take care.